Welcome to Practicing by Algorithm, the Ethics of AI for Lawyers. I'm Max Goosen. I'm president of the Beverly Hills Bar Association's Barristers section. I'm delighted to introduce our speaker, Mary Baldwin. Mary Baldwin is a shareholder in the San Francisco office of Rogers Joseph O'Donnell. Her practice focuses on representing lawyers and law firms, including litigation, ethics, and risk management advice, and state bar disciplinary defense. She's a specialist in legal malpractice law, the California Board of Legal Specialization, and the former chair of the State Bar of California Committee on Professional Responsibility and Conduct. All right, Mary, I'm turning it over to you now.
All right. Well, thanks a lot, Max, and welcome everybody. I think we have a big audience today, and I'm really excited to join you. For those of you who are here watching live, please do feel free to send in any questions. I'll be monitoring those and happy to answer questions as we go through something that comes up because there's a lot of different places in which you might have questions today. And I also am very interested, given the topic, in those of you who are actively using AI, any comments or observations you want to make as we go through. I would also expect that a number of you haven't actively used AI in your practice to this point, and we will accommodate everybody today. So do feel free to ask me questions so that we can make sure everybody gets something out of this. All right, so let's just start with a definition of AI straight from ChatGPT itself. So ChatGPT defines artificial intelligence as the simulation of human intelligence in machines, enabling them to perform tasks that typically require human cognition. This encompasses abilities such as learning, reasoning, problem solving, perception, and language resolution. Now, language understanding. All of those things we just talked about in that definition, of course, are skills that we bring to our practice as lawyers. And in fact, while this is a general definition of what we might think of as, AI, there are, of course, more specialized forms of AI that are becoming increasingly utilized as part of legal practice. One, of course, is generative AI, which ChatGPT itself is, which is a large language model trained system where, and I think most of you are very, very familiar with generative AI just from the level of attention that these products are getting, just generally publicly and in terms of, use in everyday life. But they're also, of course, increasingly utilized in the practice of law. Something that is becoming also very frequently utilized in the practice of law is something called agentic AI, which is slightly different than generative AI in that it's really a system of artificial intelligence that autonomously can plan, reason, and execute complex multiple tasks, basically getting pretty close to how humans might approach certain tasks and do that without human intervention. So if you think of, if those of you who have used ChatGPT and other generative AI products, you know that you start a query or a chat by entering a prompt, and then the system will provide an answer, and you are invited to add more prompts and further refine the tasks that you are asking the tool to do. In an agentic AI system, there's much less interaction because once you ask the tool to do something, it then goes through a series of steps, and it will usually provide you some description of what it is doing, how it is organizing it, the approach that it's taking to the problem, and what it's doing. But it takes longer and does not require you to keep entering new prompts and refining. So you can, just in that general description, you can see that there's kind of levels of AI and with significant implications for how we utilize them in practice, and more specifically for what we're talking about today, the ethical implications of using them. So let's just take a step back You may remember that ChatGPT debuted in November of 2022. Uh, that's, 3 years ago almost. It feels like a lot longer in terms of the impact on just how we do things, um, the way that the sort of economic marketplace gets structured, the impact on jobs, and just everything else. But 3 years ago is when it really happened. Uh, in 2024, so last September, there were estimated 200 million active users, about 100 million per week. I only know that statistic because I was giving, an AI talk last September, so generated that data and plugged it in. In September 2025, just to give you a point of comparison, estimated 728 million weekly users. So look at the difference from last year. And then October 2025, it's even higher than just a month ago. It's estimated 800 million users a weekly of ChatGPT. Now, you might be saying, well, that's fine. It's one thing for, my child to use ChatGPT in approaching a, social studies paper. But what about lawyers? Well, it, anybody who practices in this day and age is bombarded with daily articles in the legal press, advertisements, solicitations, informational emails about the use of AI in practice. And it's very hard to know how many of these products have been taken up for widespread use by lawyers. But the ABA collects a lot of data about the tech use of lawyers, and it appears that between 40 and 70% of lawyers use AI products daily. Now, again, don't know the legitimacy of those statistics. Based on my conversations with lawyers, and I do a lot of talking about AI and work within this area. That doesn't surprise me, and it might, and I think it seems right, but that's just an anecdotal impression, and I don't know any more than anybody else. Suffice it to say, the AI is certainly becoming a part of our legal practice. So, those of you, who've been using AI or starting to use AI might be familiar with some of the uses of AI and the types of tools that are available for lawyers. And of course, I'm moving here from a discussion of just general, publicly available AI tools like ChatGPT or, Perplexity, or, any one of the many just generally available AI tools, to tools that are fairly focused on lawyers and are designed to perform certain tasks that lawyers need performed. So, document review AI tools. This has been something, of course, that people have been using AI for, for quite a while. And we have AI-powered platforms like Relativity or Everlaw, technology-assisted review. That's something, of course, that was really an early adoption by the legal field of AI tools, because in document review, large-scale document review, using AI has really cut down on the amount of time involved. Legal research, Westlaw Precision, Lexis Plus AI, Casetext, CoCounsel. Those are some of the products you may be familiar with. We're going to talk about legal research in a little while, and about some of the ethical challenges in particular of using AI for legal research. Document automation, Litera Create, Gavel, Smokeball, Afterpattern. Those are some of the names of some tools that are available. Knowledge management, Lupul, Harvey, iManage, Insight. Editing, proofing drafts. There are different products available for that. Kira, Luminance, Spellbook. Litigation analytics. It's a very interesting and developing area where AI is used to, for example, provide predictions about the outcome of certain arguments before certain judges, for example, and providing all types of analytical tools designed to allow lawyers to analyze specifically issues and potential outcomes in a given matter. Marketing, so moving from, tools that address lawyers' use of products in their legal practice, in other words, providing client services, to sort of related products and related activities that lawyers nevertheless engage in, like marketing or firm administration, billing, timekeeping, accounting, meeting tools, all of those things. So this is just a quick snapshot, but it gives you an idea of the potential reach of AI into legal practice. And not only for lawyers, of course, it's also addressing our staff functions and our non-legal services kind of uses. I mean, marketing, for example, is a potentially really great use of AI tools. And for that, you don't need to even use legal specific tools. ChatGPT can provide great marketing support. There are, in terms of firm administration, there are a lot of specific products that are being developed, including AI billing tools that allow lawyers to more easily track time, and then AI tools that will, generate firm bills for attorneys much more easily, do accounting, all those kinds of things. So there really is, and this is only the tip of the iceberg. This is just the beginning. Again, we're only 3 years in, and this is just going to keep developing at a very, very fast clip. And I'm sure those of you who work with either Lexis or Westlaw are getting a lot of outreach from those providers because their tools are being developed, and they have new tools all the time, and it really is quite astounding to see the pace of change within the practice. So that brings us, it's one thing to sort of observe the use of AI in our practice, but what we're here today to talk about is, not only what people are using and how they're using it, but how are ethical duties implicated by the use of AI by lawyers. And when you think about it, I would say that basically almost all our ethical duties are implicated by AI use. Um, and I've done, listed some of the materially, obvious ways that our ethical duties can be impacted by AI here. The first and foremost always is the duty of competence in Rule 1.1, and we're going to be talking about this quite a bit. This is one of the most sort of areas of low-hanging fruit where we see violations right now of lawyers' duties by the use of AI, and I think there are a lot of interesting reasons for that, but hold that thought. Diligence, client communications, that listing client communications here implicates, for example, when does a lawyer need to tell a client that they're using AI in connection with providing legal services to that client? Interesting question, actually, and I think the answer to which has really changed over time. 2 years ago, I would have said to you that, and not just what I say, but the prevailing wisdom would have been much more sensitivity to disclosing a lawyer's use of AI to a client. Now, given the pervasiveness of AI tools within the practice, there's, I think, much less sensitivity and much less perceived need to inform a client about the use of AI in the provision of client services. Fees, Rule 1.5, this is a really interesting area because, of course, for those lawyers who charge clients by the hour for legal services, using AI tools generally is going to mean that services are provided much more quickly. At least certain services, something that would have taken a human hours to research can be done, almost instantaneously by a generative AI tool. Now, that doesn't mean the end of it because the lawyer still has to follow up, and we'll talk about that in a minute. But suffice it to say that there is almost definitely a saving of time involved when using AI tools. So the question it gets raised, well, then how do lawyers who charge by the hour charge for that time? And pretty, clearly, given the ethical rules that govern how lawyers charge for their time and the nature of the attorney-client fee arrangement, lawyers are only authorized to charge the amount of time that they spent, unless there's a separate agreement reached between lawyers and clients around the use of AI. And particularly where, for example, the law firm has spent a lot of resources and money to develop their own proprietary AI tools. For example, the law firm might devise a different way of charging a client for the use of those tools than simply an hourly rate. But where there is an hourly rate and where a lawyer uses AI and cuts the time spent on the task, the lawyer can only charge that client ethically, can only charge that client for the actual time spent, unless, again, there's an informed agreement reached separately with the client. That's just an example of how that particular ethical duty is implicated. Confidentiality. This is very important and certainly has been a major focus of the kind of legal community's adoption of AI and identification of potential risks. And we're going to be talking a little bit more detail about confidentiality below, along with competence. Those are two that we're really going to focus on. Prospective clients, candor towards the tribunal. Uh, in early days of AI tools, there were a number of judges across the country who adopted standing orders or rules requiring lawyers to disclose to judges when they used AI as part of a briefing that was submitted to the court. We don't really see so many of those now, and I think some of those have been withdrawn by judges, frankly, because it's almost impossible now to generate a brief without some use of AI. Even if you just use, for example, a simple Westlaw tool, there will be some use of AI there, and it starts to become meaningless. However, some judges, still have those in place, and I think there is a concern. These days, I think candor to the tribunal, frankly, is implicated more often when there has been a mistake made and the judge requires disclosure of exactly what was done in connection with a brief submitted. And then, that obviously there's an obligation to provide a detailed and true and accurate description of what the lawyer did, which has a lot of implications. Supervision. This is where particularly the need for lawyers to supervise others within the firm, so that lawyers have to know what's going on and have to implement effective policies to address particularly the use of technology and the use of technological tools such as AI. It's not enough for lawyers to simply turn a blind eye as to what subordinate lawyers are doing. You need to know. Similarly, lawyers who are supervised by others need to make sure that they understand what the rules are, and also to involve their supervisors when appropriate, particularly when there are questions that come up in terms of how tools should be implemented and how the results of using tools should be utilized. The unauthorized practice of law, Rule 5.5. This is a very interesting issue which we won't discuss a lot today. I did just want to highlight it and spotlight it as an issue. The question that comes up, particularly around very sophisticated technological tools, is to what extent are the tools themselves practicing law and therefore violating the rules against the unauthorized practice of law. And we don't have a lot of guidance here. This question perennially comes up. It started way back in the days of TurboTax and has, continually emerged again and been addressed and moved forward. And I haven't heard of regulatory efforts right now to try to define and or limit the use of tools, including going back to the beginning when I talked about agentic AI, which again gets us pretty close to how humans reason and approach things. I have not heard of regulators specifically trying to limit the use of agentic AI. I don't rule it out, and it's something to definitely keep our eyes on. And then advertising. I think advertising is very interesting, and particularly right now, and I would say particularly in California, where we have the legislature taking an interest, shall we say, in lawyer advertising and the ways that lawyers advertise. And the use of AI tools to conduct advertising, and particularly to reach out to potential clients through more sophisticated means. I mean, we've always had kind of lead generation through online platforms. With AI, of course, that just is the room, the possibility is that it could become much more targeted, much more sophisticated, and the California legislature is concerned about lawyer advertising, and there's implementing new limitations and new remedies for violations. So that again is something to really pay attention to, and I think we're going to just see an explosion of uses of AI tools in advertising, and then ethical guidance, and then means to address potential misuse. Okay, so let's start with the first of our two principles that we're going to look at a little more closely. So this is competence. So competence is defined in terms of the ethical duty in Rule 1.1 in particular. We also, of course, have a sort of common law definition of competence, which is defined as the standard of care, and that's the standard that gets employed in a negligence action, which would be a civil action brought against a lawyer for legal malpractice or some other breach. And those are two sides of the same coin. Competence is how we define this ethically. Standard of care is how we define competence for purposes of liability. But the ethical duty says that that lawyers have to maintain competence in the provision of legal services, and that this duty includes an obligation to keep abreast of the changes in the law and its practice, including the benefits and risks, sorry for that typo, risks of technology. And that's Rule 1.1, Comment 1. Interestingly, this is a newer comment. It was just adopted a few years ago. It was not adopted when the rules were finalized in 2018. But we do have it now, and this is something taken right out of the model rules, and it's something that often gets invoked, of course, when we're talking about technology, because it specifically tells lawyers that they need to keep on top of changes in the law and its practice, and understand the ways in which technology benefits clients and assists lawyers in the provision of legal services, but at the same time understanding the risks of that technology. So the implications of this duty for lawyers means that lawyers really have an obligation to understand at some level the tools that we use as lawyers. So I'm not an engineer. Most of you are not engineers. Maybe some of you are. But we certainly don't have to fully understand how the technological tools that we utilize function, but we do have to have some understanding about how the tool works, and particularly, going to the second part of this comment, the risks of that technology. So, for example, with competence, what are the risks in using this tool? In what ways could using this AI tool threaten my competence as a lawyer? In what ways can I not safely rely on it, for example? You have to understand those aspects of your use of the technology. And particularly with AI, you will certainly need to think about, is this a tool that was built with lawyers in mind? Because the tools that are built and developed for use by lawyers, they will generally have in place, certain safeguards to try to limit certainly in the context of competence, the mistakes that might get made by the tool. In confidentiality, which we're going to talk about in a little while, tools that are built for lawyers generally will include safeguards against the risk of disclosure of client confidences through the tools. But publicly available AI products won't generally have those kinds of safeguards. And this was an early concern in the use of ChatGPT by lawyers, and it's a continuing concern in terms of competence when we talk about hallucinations, which we're going to get to in a minute. So just to understand that always lawyers have that threshold duty of competence. And it means that we have to understand the tool. It means we have to double check and make sure that the results that the tool is providing to us meet the standard that we are being held to. And it's something that might require the development of new skills. For example, that I have here at the bottom, skill development, prompt engineering. Certainly understanding how to ask an AI tool the question in the right way to generate the answer that you want. That's an obvious area of developing skills where we have to develop our competence as we use these tools. We all learned when we started to use Lexis or Westlaw, we all learned how to generate searches and utilize search terms in the use of those tools. This is no different. I will say, as I mentioned at the beginning, that with agentic AI, the way that we frame questions and the way that we ask the tool to conduct tasks is a little bit different than how we might do in another generative AI product, such as ChatGPT, where you're using kind of evolving prompts. But in any event, you have to understand how to do that in order to get the result that you want, that you are using the tool to try to provide. Now, ChatGPT debuted in 2022, as I said, right away, almost right away, within months. We had our first example in the legal press of a lawyer's misuse of AI, and this was this Mata v. Avianca case. The case cited here is from June 22, 2023, but the lawyer's misuse of the AI happened in February when he submitted a brief that was full, as it turned out, of hallucinated case citations. What is a hallucination in AI? It's a made-up case cite. That might mean a completely made-up case where the whole site is made up. It doesn't even exist in any way. Or it might be a hallucination that includes an actual case name, but a completely made up holding, completely made up facts. They might correctly identify the name of a judge, but this judge had nothing to do with the case. For example, there's many different permutations of possible hallucinations that AI may produce when you use the tool for legal research. Why is that? Partly it's because generative AI is designed to try to give you what you want. Generative AI tools want to give you what you're asking for, that they generate. That gives you your first clue. And sometimes they will generate false citations in order to give you an answer. And that's been a real problem. Now, I will say, back when Mata v. Avianca came out, and of course I'm an ethics lawyer, I'm very interested in technology, I thought at the time, well, this is an interesting example of misuse of AI. Better talk about it quickly, because I doubt this will keep happening. Well, lo and behold, it's continued to happen and keeps continuing. In fact, I'm going to just leap ahead to this slide. Next slide. So there's this website by this AI researcher, Damien Charlatan. He maintains a website reporting cases that involve hallucinated case citations. He had listed there over 455 as of October 21st, 2025, last week. Well, I checked today before we got on. It's 487 today. So in the space of 7 days, there are 32 more reported cases involving case hallucinations. That's a lot, and the numbers aren't slowing down; they're picking up. And I just find that very, very interesting, because really hallucinated cases are the low-hanging fruit of possible misconduct and incompetence using AI. Why? Because it's so easy to go and verify the case citations that you get from AI. It's simple. You could even just use the regular old Google. You don't even need to go to Westlaw or Lexis or some other case citation tool to verify a case citation. Yet, lawyers are not doing it. Well, they are doing it, but many other lawyers are not, and they are submitting cases to courts that are false. And that's a serious problem. And I have to say, I'm so surprised that it keeps happening. And I think I think there are reasons why, and I think it's important to think about why. And we're going to talk about that in a few minutes because I think that has implications for us as we talk about the ethical use of AI. But it's not just lawyers. Going back to the previous slide, I noted there that there are judges that have issued opinions that, as it turned out, had hallucinated case citations in them. Two, if, for example, over the summer, two different federal judges who are now facing investigation by the Senate Judiciary Committee. And just last week, I think, each submitted responses to the Senate Judiciary Committee explaining why this had happened in their courtroom. There was an expert in a case involving AI use, and this happened to be a professor at Stanford who specializes in AI. He submitted an expert report in a case in Minnesota, and this was last summer, I believe, meaning summer of 2024 or late 2024. And it turns out that expert report was full of hallucinated, not cases, but hallucinated references to academic articles. And, the judge who was presiding over this, when he was looking closely at this, he was outraged. The expert, for a lot of reasons, and the expert, as part of explaining what had happened, said to the judge, I am very, very careful in my academic work, and I always double check, and for some reason I just didn't do so here. And the judge took offense, saying, oh, so you can be careful in your academic work, but sloppy in what you submit to me. The judge was not happy about that and imposed some significant sanctions. And in fact, there's it's worthwhile to look at the kinds of sanctions that that judges are imposing. I will note I'm going to go on to the next slide. There's a relatively new, it's from, about a month ago, a little bit over a month, 5 weeks ago, published case in California. It's the first published case from the State Court of Appeal that I'm aware of in California, where appellate briefs included hallucinated case citations. I believe it was the plaintiff's briefs, both the opening brief and then the reply. And these were non-existent cases, and also citing cases for propositions that the cases did not support. So a number of different ways in which the hallucinated cases did not support the ways in which the lawyer was citing them. And the court, it makes for a good read. The court is angry, frankly, about this and says, at this point in time, you should be aware of the potential misuse of AI in the form of hallucinated cases, and you should know already what to do and how to competently practice when using AI tools, and issued a $10,000 sanction reporting to the state bar and required that lawyer to serve the opinion on the client and the bar. So, pretty significant. We're going to talk a little bit in a few minutes about the implications of that particular decision and what it suggests about the evolving standard of care and standard of competence for lawyers in terms of using AI tools for legal research. But I also want to note that in addition to sanctions, which I think, as reflected in the reaction by the court in Noland, and this is true in a lot of other courts, the kind of amount of sanctions that courts are imposing for misuse of AI is increasing. And I think that's partly because courts, like the court in Noland, are saying, look, we might have given you some leeway early on in the use of AI, but at this point, there's no excuse. And everyone needs to know how to use AI competently and safely, and everyone knows how to comply. Everyone needs to know how to comply with their ethical obligations. So, we've seen sanctions. I've seen sanctions of up to, I think, $30,000 for hallucinated cases. And then in other cases, Noland was 10,000. The original case, that Mata Vavianco, I think was only 500, just to give you a little bit of a perspective. Many courts are referring lawyers to the regulatory authorities, in this case, the California Bar in California, for possible discipline. And I am aware that the California Bar is already considering some disciplinary cases involving misuse of AI. There's been terminating sanctions or issue sanctions that courts have issued against the cases where lawyers have submitted AI hallucinations. You might argue that that's an unfair penalty imposed on a client for lawyers' use of AI, but it's a risk, and it's not. This is not the only instance in which lawyers can do something that ends up in prejudice to their clients because of something the lawyers do. And I think we also have seen some interesting other forms of sanctions that courts have imposed, things like requiring lawyers to send letters to judges that have been miscited in the lawyer's brief because of the hallucinations, or a recent case where a lawyer was asked by a judge to choose whether they wanted a monetary sanction or whether they wanted to agree to engage in a series of lectures and education of lawyers to try to educate lawyers about the possible misuse of AI. I'm sure, I don't know which one the lawyer selected actually. I think I would have chosen the latter, but who knows? But I think we'll continue to see escalating sanctions. I think we'll continue to see creative solutions by courts, and we absolutely will see discipline that regulatory authorities will impose for the misuse of AI. And this is only we are just seeing, with the rise of these numbers of cases and the increase in guidance being set forth by courts, it's only becoming more and more clear what the standard of care is. So it's more and more important even now that lawyers understand their obligations. Before we get to this little compliance checklist that I generated with the use of the assistance of ChatGPT for how to comply with the Noland case, I do think it's useful to think for a few minutes about why lawyers continue to misuse AI in this way. And I'm specifically talking about the submission of briefs with hallucinated cases. Because I think we're going to see the misuse of AI evolve. I think lawyers are going to misuse AI and violate their ethical duties in a whole lot of different ways, many of which we haven't even thought of yet as the tools evolve and become more sophisticated. But this, again, the hallucinations provide such an easy way to look at this problem and get some insight into the potential ways in which lawyers might misuse AI going forward. And I think there's a lot of reasons why lawyers have misused AI, and why lawyers continue to submit hallucinations. And there was an article recently, I think in Law 360 or something else, where the author did a survey of why lawyers in these various cases said that they had misused AI and had submitted hallucinations. And the answers kind of run the gamut. And I think if I did a survey, if we were sitting all in one room and I asked you guys to vote on the possible reasons that lawyers might give as to why this happened, I think we'd probably hit upon a lot of the reasons that lawyers actually have given. One is, of course, lawyers who just don't have enough time, or say they don't have enough time to do the task that they've been asked to do. Lawyers who don't have enough resources to do. Maybe lawyers don't have access to Lexis or Westlaw or some other research tool, so they turn to something that's publicly available like ChatGPT. Reliance on others' work is something that is frequently cited. Either reliance on, say, their clients to help them with research, reliance on paralegals, contract attorneys, others in the firm. It's, always easy to blame someone else. And of course, let me just say, and I'm sure you all understand, it's not enough to blame someone else. That does not excuse a lawyer's own conduct or misconduct in this instance. A lawyer always has the obligation. So, suggesting that it's somebody else's fault is not going to be an effective defense. Nevertheless, people keep offering that as an explanation. A lack of understanding of how the technology works. So many lawyers, and this excuse is starting to run thin, I think, as time goes on. But lawyers should say, I didn't understand that the technology could generate hallucinations. I had no idea. This seemed like a good tool to help me do what I wanted to do. That just is not going to fly and especially not as this continues to go on. Everyone needs to understand the risk of hallucinations, even with the best tools, even with the best tools that are designed specifically for lawyers. You need to understand there is a risk of hallucinations. Just plain old mistakes by lawyers or a failure to communicate among members of a team. Sometimes the senior lawyer doesn't understand that the junior lawyer who drafted the brief used AI, doesn't even think to ask that the research results be double checked. Often a pressure on lawyers to save time and money in doing a particular task. And I think bottom line, just stress that lawyers are under. And all of these factors are going to continue to exist, and all of these factors are going to continue to incentivize lawyers to use AI, because AI is an immense time saver, and it can just cut through tasks in such an efficient, quick way that lawyers will absolutely continue to use AI and will continue, if they don't understand the risks and don't understand what they need to do as they use those tools, they will continue to misuse AI. So, as I said, I just wanted to give a little example. I just used ChatGPT for this. Very easy. I asked ChatGPT to generate a compliance checklist on how lawyers can comply with that recent California case, the Nolan case. So the ChatGPT came up with a very nice, concise little checklist. One, confirm that the case cited actually exists and that's properly published. Second, make sure that any quotations are accurate. Personally read the case. Ensure that the quotations exactly match. All good advice. 3, verify the actual citation accuracy and, of course, pinpoint cites. 4, verify the proposition support. Make sure that the case actually stands for what you're citing it for. 5, this is good, treat your AI output like a junior associate. So don't just simply rely on it and submit it to a court. Review the work, double check the work, verify it against the original source. Excellent advice. Final review, double check footnotes, block quotes, parentheticals. Excellent. Documentation, this is an interesting point. Keep a verification log. Save notes, screenshots, or copies. And many AI tools will allow you to save the chat. Good idea to save it so you have a record of what you actually did. The reason this is important, and the distinction between, say, using an AI tool versus the old Westlaw or Lexis, the way we would use it, is that Westlaw and Lexis, you knew what the tool was doing. You knew the basic database. It was published cases, or actually not even published cases, all cases available and opinions, and you would run a search against those. You knew what the tool was doing. The AI tool, for the most part, is a black box. You don't actually know. And so it's hard to replicate the results of a particular search from one day to the next. The tool is always training on more data, more data. So it's really important, and I would say potentially more important when you use an AI tool, to keep verification of what you've actually done and put that as part of the client file. So, and just I'll leave you with this from Nolan. The case itself, and the court in that case, suggested that no brief, pleading, motion, or any other paper filed in any court should contain any citations that the lawyer responsible has not personally read and verified. Now, that's a strong statement, and I don't know that most lawyers would understand that that is their personal obligation in submitting a brief. And maybe we'll see the standard evolve, but important to understand that is how courts are looking at this right now, and explains why they're getting so angry when lawyers are violating these rules. So now let's move from competence to confidentiality, which I think you could suggest is somewhat less of a concern as our use of AI tools evolve, and particularly as our use of legal industry specific tools evolve. But let's take a step back. Obviously, we have a duty of confidentiality, which is set forth in Rule 1.6. It's also in California set forth in our Business and Professions Code 6068E. And this is a pretty heightened obligation of confidentiality. We have the duty to not use or disclose any client confidential information, which is defined very broadly as any information relating to the representation. So very, very broad. It's much broader than what is encompassed by the attorney-client privilege, which are confidential communications between a lawyer and a client in the course of an attorney-client relationship. So you could think of, the duty of confidentiality as pertaining to a large amount of information, and privilege as pertaining to a small subset of what is covered by the larger duty of confidentiality. But it's important that lawyers understand we have this broad duty. The way in which this is implicated in the use of AI tools is particularly with publicly available AI tools like ChatGPT and other tools, unless the tools specifically protect against users' information that, for example, that users input as part of a prompt. Anything that you input into that tool is going to be utilized by the tool. The tool is going to train upon that data. It just becomes part of the vast amount of data that the tool uses going forward. So I think lawyers didn't understand that in their early use of AI tools, and I think it's something that lawyers increasingly understand. So, for example, when you might meet with a legal product vendor and talk about an AI tool that has been developed for the legal industry, confidentiality is going to be something that comes up pretty early in that conversation, and generally that tool they will have taken steps to protect against any disclosure of client confidential information or any use of information that you input into that tool beyond for your own particular query. So, and it's important to understand, and this goes back to our duty of competence and understanding the risks and benefits of technology. You need to understand what will the tool do with the information that I input. Can I input client confidential information? For example, can I input an attorney-client privilege memoranda for the tool to use as I then ask questions about it? You need to understand what are the protections in place to ensure that that tool will not then use the client confidential information that you input. And if you don't have those protections in place, you have to be very careful not to input client confidential information. And it's really critical to do because you will be violating a core duty, a part of our fiduciary duties to our clients. So be very careful about that and really make sure you understand. Read the terms of service, talk to, for example, the people who oversee technology in your firm. Talk to the vendors who are, trying to get you to use their product, and just look and see what the actual use of the client data might be. Now, going back to what I said earlier about client consent and disclosure, again, given the ubiquity of the use of AI tools at this point, I don't think that there's a general obligation to disclose to clients when you are using an AI tool in the course of providing legal services to that client. The exception might be if you are using an AI tool where there is a risk, for example, of a breach of client confidential information. Not that, consistent with what I've said before, I don't recommend that you use that kind of tool because I think it's inconsistent with your duty, but perhaps there's some reason, maybe the client has even requested you to use a particular tool, which is an increasing phenomenon that lawyers are seeing, where clients want lawyers to save money and are asking lawyers to use AI tools, or clients themselves are taking, for example, a draft brief that a lawyer provides them and running that draft brief through an AI tool to get ideas about edits or other material that they might use. Now that's an important thing for lawyers to think about, because that particular phenomenon of clients running attorney work product through an AI tool that needs a lawyer to say to a client, there are risks. When you run confidential work product of mine in a publicly available AI tool, there's a real risk that you have created there, and you need not to do that. And lawyers might need to think about having that conversation with their clients ahead of time and anticipating when a client might think to do something like that. But going back to client consent, if there's any possibility of risk to a client through a lawyer's use of an AI tool, I think that is a situation in which lawyers should disclose their use to the client, and get the client consent. Early on, and I think this was the summer of 2023, a lawyer in DC in a case involving um, claims for political fraud against Braz Michel, who's a singer, a member of the Fugees group, who's also a political lobbyist. Apparently, he was on trial, and the lawyer conducted his closing argument, as it turns out, using a draft closing argument that was generated by an AI tool. The client cited that as part of the basis for a motion for new trial, saying that it was negligent, that that use should have been disclosed to the client should have been allowed to give consent, and some other related claims, including a conflict claim because the lawyer apparently owned an ownership stake in the company that he used to generate that closing argument. Uh, in the end, the court did not accept that as a basis of a new trial, but it goes to show that in that instance, and again, this was an early example, not sure we're really there, but it was a use that potentially created some risk to the client, and arguably should have been disclosed, especially with this element of the lawyer's part ownership in the company. All of that, I mean, you sort of can't make this stuff up sometimes. But I think you could, on that example, it's probably not a great example for where we are right now, because I think we all would understand that the lawyer shouldn't have simply used the output generated by that AI tool to then turn around and give the closing argument. Let's go back to that guidance from Noland. Treat this like a first-year associate. Take that. It could be a good start. Why not? But the lawyer has to use the lawyer's own judgment and independent judgment, independent thinking, our training as lawyers to then bring to the output that the AI tool provides us. And that is what's going to help us meet that duty of competence every time, whether it's hallucinations or something else. Don't forget that we are the lawyer, not the AI tool that we're using to help provide legal services. So I've touched a little bit on some of these other ethical issues that could be implicated in the use of AI. And maybe now that we've walked through some of this, some of it might become more apparent. I do think the supervision of lawyers and non-lawyer staff is very important. And I think that lawyers, whether you're in a law firm, whether you're in an in-house legal department, lawyers have to give thought to what is an appropriate AI use policy for lawyers that they work with. And this is an area that is under significant evolution because, frankly, a year ago, if we had talked about what lawyers should do in terms of devising an AI policy, I think we would have had sort of a strong interest in policies that prohibited lawyers from using AI. And I think that has really changed now because of, again, the ubiquity of the tools, the utility of the tools, the ways in which they both help to provide legal services more efficiently and more cost effectively. So I think that it's not realistic at this point in most cases for lawyers to have a no-use policy, but it's very important for lawyers to devise a policy that strikes the right balance within the lawyer's own practice for how lawyers can use AI, when they should use AI, and particularly the safeguards that should be in place in the use of AI. And it's not enough to just ignore this problem and hope that it kind of goes away, because it's not going to go away. And I think lawyers, more senior lawyers who don't make an effort to understand what tools their lawyers are using are making a big mistake, because you need to understand what tools the more junior lawyers are using, and they are using AI. There's really, I can't even imagine a context in which lawyers aren't at least trying AI tools for at least some to get started, for example, on a research project, or background information on clients, or whatever it is. And that's appropriate. That there's nothing wrong with doing that. Again, as long as we bring our own independent judgment to that and double check and verify at every step. And I would also say on this point, going back to that comment that defines the duty of competence in Rule 1.1, I think lawyers also have a duty to try to understand the utility of these tools. So I would encourage everybody to be trying AI tools, to be experimenting with them, not inputting client confidential information, not using them for particularly sensitive client questions, maybe even not using them for client matters at all, but learning how the tools work. If you get access to a trial, through Westlaw or Lexis, for example, your provider, take advantage of that trial when they make these products available to you for free or for very low cost, because these are very expensive products, mind you, and the more sophisticated the product, the more expensive it is. But within your practice area, there very likely are very sophisticated AI tools that could really help you provide legal services to your clients in a better way than you're doing now. So this is something we all have to become familiar with and develop some level of expertise. And then these other issues, I've touched on. Oh, the last one, let me just mention this. So required reporting of others' misconduct in accordance with Rule 8.3. As California lawyers, we all know that, we never had a reporting rule where we were required to report other people's misconduct. As of 2 years ago now, we do. So we are now required to report other lawyers' misconduct to the bar in certain instances. I would say that in terms of AI use, it's going to be very rare that we would have an obligation to report AI use, unless the person who was misusing that AI was doing so in a way that was fraudulent or somehow intentionally deceptive. So hopefully you're not going to come across that situation very often. But if you did, you would then potentially have an ethical duty to report that misconduct. So, just another obligation to throw onto your plate. In terms of ethics guidance, we've touched on a lot of different issues here today. If you're interested in learning a little bit more or seeing a deeper dive of any of this, there's an ABA formal opinion from July of 2024, over a year ago, but still a pretty good overview of some of the ethical rules and how AI implicates those ethical rules, and particularly how we analyze the application of these rules to AI in a particular instance. You can get that at the ABA website. There's also lots of opinions from a lot of other jurisdictions. They kind of come out all the time, as you would imagine. Ethics opinions are non-binding guidance that a court certainly doesn't have to follow, but it's helpful. And if you have an ethics opinion to support, for example, something that you did, maybe a judge is asking you to explain how a hallucination ended up in your brief, for example, you might look to the ABA ethics opinion, for example, to see if there's any help for you in terms of what might be set forth there about lawyers' obligations. The California Bar issued some practical guidance for the use of generative AI, and this was from November 2023, which is, almost 2 years ago, but still, frankly, a helpful document that is available at the State Bar website, and you might look at that too to get some ideas. That might help give you some ideas for generating your own law firm AI use policy in the way that it identifies ethical issues and ethical concerns, particularly with respect to our California rules. So you might look at that as a resource. Overall, and a quote from that practical guidance, and this is a good thing I think to leave on, a lawyer's professional judgment cannot be delegated to generative AI and remains the lawyer's responsibility at all times. A lawyer should take steps to avoid over-reliance on generative AI to such a degree that it hinders critical attorney analysis fostered by traditional research and writing. And, that is a great thing to take away from here. It's a great sort of overriding principle as you use AI in any context in connection with your practice. And as AI tools evolve, this principle is going to remain the same, and you just want to take steps to make sure that you are always complying with your ethical duties as you use these new technologies. So with that, we will just end it here. Thank you very much.